Welcome back, everybody. The Constitutional Court last week gave Parliament 24 months to address the discrimination present in the Recognition of Customary Marriages Act of 1998, which does not provide any protection to women married in terms of customs in polygamous matrimony prior to the act coming into effect. Now, the judgment extends the protection envisaged by the Recognition of Customary Marriages Act to women married in polygamy, and that wives and husbands will have joint and equal ownership and other equal rights of management and control over marital property. We are joined by Sharita Samuel, the Durban Regional Director of the Legal Resources Centre. A very good morning to you, Sharita. Thank you so much for joining us. What a groundbreaking judgment. What does that judgment advance, or how will it advance women's rights in the country?
Hi, good morning, and thank you for inviting me. Essentially, what the judgment does is that it extends the right of ownership in terms of marital property to women who were married according to customary law and in polygamous marriages prior to the commencement of the Recognition Act. I think you have summarized it very well by saying that women will now enjoy equalship, control and management of matrimonial property in terms of this decision.
So what were the loopholes in terms of Section 7 of this said Act for women in pre-1998 polygamous marriages?
Well, it wasn't really a loophole, but essentially what the Recognition Act did was that it did not grant the same rights that it did to women who would be married after the commencement of the Recognition Act to women who were married prior to the commencement of the Act, according to, in polygamous marriages. It limited their right, and it almost left them it left their marriages to be governed by customary law, whilst women who were married after the commencement of the Act were protected by the provisions of the Recognition Act. And we believe that this was unfair, and it discriminated against those women who were in the old customary marriages and old polygamous marriages.
As I was going through this judgment, the court has found that by refusing to recognize women married prior to the Act coming into force, the legislation is markedly discriminatory against women. So what does that Act say now about women married in monogamous customary marriages?
Well, monogamous customary marriages were also affected, and the Legal Resources Centre actually did an earlier case, which was Gumede versus the President of South Africa, where we challenged this exact same provision in respect of monogamous customary marriages that were entered into prior to the commencement of the Recognition Act. So the Legal Resources Centre has actually litigated on behalf of monogamous customary marriages earlier, and now in respect of polygamous customary marriages. So our first case, decided that the protection would be offered to women married in monogamous customary marriages. But as time goes, the legislature cannot provide for every single situation. And it so happened that the LRC was consulted by our client, Mrs. Mapumulu, and her facts were that she was married according to polygamous customary marriages and prior to the commencement of the Act. And we had to look at the Act again, we had to look at the Gumede judgment, and we had to see whether we could extend this Act further in order to cover another category of women that was not foreseen or provided for in terms of the Act. And that is the work of the Legal Resources Centre. That is what we do. We try and extend existing law so that citizens are covered as they are intended to be by the provisions of the Constitution.
I'm curious to know, Sharita, how did this part of the legislation make women dependent on their husbands?
Well, it's not the legislation, it's not the Recognition Act which makes women dependent on their husbands. This is a system of customary law. Customary law determined that women married according to African customary law were regarded as minors, that they were not allowed in terms of that law to acquire, own, or manage or control property, household property or marital property that had been acquired during the duration of that marriage. And the Constitution, as we all know, does not subscribe to that kind of control and inequality. And the Recognition Act was an effort by the legislature to bring that customary law in line with our Constitution and the requirement of equity and equality. But the Recognition Act did not go as far as it was required to, based on the needs of the different women, men, and children in our country. And accordingly, when we come across legal problems such as our client's, Mrs. Mapumulu's, then we have to look at our legislative framework to see what recourse and what relief the Legal Resources Centre can put together in order to assist her. So it's customary law that decided that Mrs. Mapumulu did not have the right to own,
I must interrupt you there, unfortunately, Sharita. We haven't got much time, but according to the order, wives who are parties in polygamous customary marriages entered into before the commencement of the recognition of the Customary Marriages Act of 1998, shall have joint and equal rights of management and control over marital property until such time that Parliament enacts legislation which governs the matrimonial property regime, such as marriages. How was this order limited?
Well, the High Court order limited the benefit to management and control. The Constitutional Court, however, has granted ownership, the right to claim ownership of the property. So just as people married according to community of property in all other races in our country have the benefit to by default get married according to community of property unless they have an antenuptial contract, the similar situation will now apply to women who are married in old customary marriages prior to the commencement of the Act. And Parliament has allowed the legislature 24 months to enact the law that will protect these women. In the interim, it has granted this relief of ownership and not just management and control.
The court, Sharita, if I'm not mistaken, also suspended the declaration of invalidity for 24 months to give Parliament time to remedy the defect in the law. Does this mean that the judgment doesn't stand until Parliament remedies the law?
No, because the court granted interim relief. The court has stated how these cases will be dealt with pending the enactment of legislation. And the court, it was very clear that it will not apply to estates that have already been wound up. It will not affect property that has already been transferred unless one of the parties was aware that a legal issue similar to Mrs. Mapumulu's is the subject of a legal challenge. So the court tried to the court has tried to ameliorate any practical difficulties that may have arisen from granting retrospectivity.
All right, Sharita, great chatting to you this morning. Thank you so much for your time. That is Sharita Samuel.
Thank you for inviting
She is the Durban, indeed, we appreciate it. She is the Durban Regional Director of the Legal Resources Centre, commenting about the Constitutional Court judgment that gave Parliament 24 months, to address the discrimination present in the recognition of the Customary Marriages Act of 1998.